The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Our first case this morning is North Carolina Farm Bureau Mutual Insurance Company, Inc. versus Judy Lunsford. We'll hear from the appellant.
Good morning, Mr. Chief Justice and Associate Justices, and may it please the court. My name is Jason Burton. I'm a member of the Wake County Bar, and I'm here today on behalf of the appellant, Judy Lunsford. I would like to allocate 20 minutes of the argument to the initial argument and 10 minutes to rebuttal. We are here today as an appeal as a matter of right pursuant to General Statute 7A-30 and Rule 14 of the North Carolina Rules of Appellate Procedure as a result of the dissenting opinion of Judge Murphy in the Court of Appeals opinion dated May the 5th of 2020. The issue on appeal is whether the Court of Appeals erred in affirming the motion for judgment on the pleadings granted by the Guilford County Superior Court, which resulted in a finding that Mrs. Lunsford, a North Carolina resident, is not entitled to underinsured motorist coverage under her North Carolina Farm Bureau policy. Because of the de novo standard of review, the court today is essentially being asked to determine if Mrs. Lunsford is indeed entitled to UIM benefits under the North Carolina Farm Bureau policy, insuring her at the time of an accident that occurred in May of 2017. When dealing with the question of whether underinsured motorist coverage applies, the court is tasked with making a threshold determination of whether the vehicle involved in the accident was indeed underinsured within the meaning of North Carolina law. To conduct that threshold inquiry, the court is required to compare the liability coverage existing on the vehicle involved in the accident with all UIM coverage insuring the injured party under any policy applicable to the accident. Because North Carolina law permits inter-policy stacking of underinsured motorist coverage in this scenario, it's Ms. Lunsford's position that she's entitled to UIM coverage under the Farm Bureau policy. North Carolina Farm Bureau, on the other hand, contends that because the vehicle Ms. Lunsford was riding in at the time of the accident does not qualify as underinsured under a Tennessee nationwide policy that provided primary liability coverage in this case, that it simply cannot qualify as an underinsured motor vehicle under North Carolina law and the North Carolina Financial Responsibility Act. We believe that that position is contradicted by established law from the North Carolina Court of Appeals, as well as the plain language of the North Carolina Financial Responsibility Act, which is written into and read into every policy of insurance issued in the state of North Carolina. By way of a very brief factual background, the accident in question occurred on May the 22nd of 2017. At that time, Ms. Lunsford was a citizen resident of Alamance County, North Carolina. She had traveled to the state of Tennessee to visit her sister, LaVonda Chapman, and the two of them got in Ms. Chapman's 2015 Chevy Silverado and headed towards a vacation in the state of Alabama. While they were traveling south on I-59 in DeKalb County, Alabama, Mrs. Chapman traveled left of center, crossed a center median, and collided head-on with a tractor trailer. Force of the impact resulted in Ms. Chapman's death and substantial injuries to Mrs. Lunsford, who was a front seat passenger in the vehicle. At the time of the accident, Ms. Chapman was covered by a Tennessee nationwide policy that provided $50,000 of bodily injury liability coverage. The policy also provided $50,000 of underinsured motorist coverage to any permissive occupant of the Chapman vehicle at the time of the crash. Ms. Lunsford, on the other hand, pursuant to her North Carolina Farm Bureau policy, had limits of $50,000 per person in underinsured motorist coverage. Now, in 2009, the North Carolina Court of Appeals in a case called Benton v. Hanford considered very, very similar circumstances. In the Benton case, Benton was a front seat passenger in a single vehicle accident, and the vehicle was being driven by Mr. Hanford. The Hanford vehicle had a liability policy with $50,000 limits. It also had UIM coverage with $50,000 limits. Benton was also covered as a family member under a Progressive Southeastern policy that provided $100,000 in uninsured motorist coverage. In Benton, the court, considering the coverages at issue, made a comparison of the $50,000 liability coverage available to Mr. Benton under the nationwide policy and compared that with all UIM coverage available under both policies. The court stacked the $50,000 nationwide UIM coverage limit with the $100,000 progressive UIM coverage limit to determine that there was $150,000 in available UIM coverage. When that $150,000 was compared with the liability coverage on the Hanford vehicle, the court found that the Toyota vehicle in that case was an underinsured motor vehicle within the provisions of the Act. Now, Benton v. Hanford we think is helpful for a number of reasons, and I would like to show the court a brief PowerPoint presentation that I've shared with Mr. Lipscomb that enunciates some of these issues. In Benton, the court went through the general definition of underinsured highway vehicle as that term is defined by the Financial Responsibility Act, which is 20-279.21. Under that general definition, a vehicle is an underinsured highway vehicle when the sum of the limits of liability under all injury liability bonds and insurance policies applicable at the time of the accident is less than the applicable limits of underinsured motor vehicle coverage for the vehicle involved in the accident and insured under the owner's policy. In reaching the conclusion that inter-policy UIM coverage may be stacked, the court cited the avowed purpose of the Financial Responsibility Act as enunciated by this court in prior case law. That avowed purpose is to compensate the victims of financially irresponsible motorists. The Act, the Financial Responsibility Act, is remedial in nature and is to be liberally construed so that the beneficial purpose intended by its enactment may be accomplished.
Counselor,
Yes.
Excuse me, I'd like to ask a question about this financial irresponsibility. I'm having trouble with your argument because is it not true that both parties were insured at the same rate? And so how could you say that that your client should get something for being from an irresponsible situation when they had the same coverage as the other side?
Thank you, Justice Behringer, for that question. It is true that the policy limits, the UIM policy limit under the North Carolina Farm Bureau policy is equal to the liability coverage under the Tennessee nationwide policy. But the holding in Benton dictates that the UIM coverage on both vehicles must be considered under North Carolina law in order to make that threshold determination. So here, under the facts of Ms. Lunsford's case, just like in Benton, where the court took the $50,000 of UIM coverage available under the tortfeasor's policy, added that to the $100,000 of UIM coverage under the Progressive Southeastern policy to reach the conclusion that there was a total of $150,000 of underinsured motorist coverage. Applying that same proposition to the facts in the Lunsford case, you take the $50,000 of UIM coverage under the nationwide policy, stack that with the $50,000 of UIM coverage under the North Carolina Farm Bureau policy to make the determination that there is $100,000 of UIM benefits. When that $100,000 is compared with the $50,000 liability limit, the Chapman Silverado is indeed an underinsured motor vehicle within the meaning of the North Carolina definition and the Farm Bureau policy.
And Counselor, though, I follow your math, but I still don't see the logic as far as the irresponsibility, because if the limits on both policies were the same, how can one person, is your client admitting that she was irresponsible too?
No, Your Honor, my client is not admitting that she was irresponsible. This goes back to the statutory definition of underinsured motor vehicle under North Carolina law. As the Benton court discussed, because of the legislature's use of the plural term limits when referring to the underinsured motorist coverage, the court is required under that language to consider the UIM coverage under both vehicles. So while it is true that the policy limit, the UIM limit standing alone under the Farm Bureau policy equals the liability limit under the nationwide policy, the case law from the Court of Appeals says that when making the threshold determination of whether a vehicle is underinsured, the court is required to consider all UIM coverage available to the injured party in making that threshold determination. So it's not a simple comparison of 50 in liability coverage versus 50 in UIM coverage. It's a comparison of 50 in UIM coverage with the stacked UIM limit, which is $100,000.
Mr. Burton, it seems, if I'm reading the briefs correctly, and the ultimate question is, am I reading them correctly? It appears to me that you and Mr. Lipscomb, one, do not disagree with Benton as applied to the facts of Benton. Is that right?
That is correct, Your Honor.
And that the principal difference between this case and Benton is whether to include the $50,000 in uninsured coverage from the Tennessee policy in determining the total amount of uninsured coverage available to the participants in this risk, right?
I agree wholeheartedly with that statement.
So the real issue before us then is whether we count the $50,000 in uninsured coverage available for the Tennessee policy in determining whether there is more uninsured coverage than liability coverage.
That is absolutely correct, Justice Urban.
All right. So let's, if we can, try to help me understand why you contend that it also appears to me, at least, that there's no dispute that, taken totally in the abstract, Tennessee law and the provisions of the Tennessee liability coverage do not make uninsured coverage available in an instance in which liability is paid out under the Tennessee policy. I didn't say that very well, but I hope that at least my statement is comprehensible. Is that right?
That is correct, Justice Urban. If you look at the Tennessee statutory embodiment in isolation and the nationwide policy in isolation, if you apply Tennessee law to the Tennessee policy, the vehicle in question is not underinsured within the meaning of the Tennessee nationwide policy. But the question for this court, as we have tried to stress throughout the briefing in this case, is not whether the Chapman Silverado qualifies as an underinsured highway vehicle under the Tennessee nationwide policy. The question is, does it qualify as underinsured under the North Carolina Farm Bureau policy?
And that is what I had understood was the issue here. Tell me as directly as you can why the Tennessee vehicle is treated as underinsured for purposes of North Carolina law, regardless of, and that the conflicting Tennessee policy provisions and statutes should be overridden in this case.
Again, Your Honor, Justice Urban, taking us back to the holding in Benton, the very same argument was made by counsel for Nationwide in the Benton case. In Benton, counsel cited to a policy definition or exclusion that said a vehicle cannot be considered an underinsured motor vehicle if it's insured under the liability portion of this policy, meaning the nationwide policy. The court dispensed with that language, read into the contract the provisions of the North Carolina Financial Responsibility Act, and reached the determination again that in this isolated circumstance, where an injured party is a front seat passenger in the vehicle being driven by the tortfeasor, that North Carolina statutory law requires that consideration of the UIM coverage on the vehicle involved in the accident and any other policy insuring the injured party from a UIM standpoint. So while it may very well be true that the Chapman vehicle is not underinsured within the context of the Tennessee policy, the question again is it underinsured within the North Carolina Farm Bureau policy?
And
to,
it's in your view, then, given that if the policy was a North Carolina policy under Benton, it would be treated, you would get the result that you're seeking, that it just doesn't, that the Tennessee law and the Tennessee policy is to the contrary?
that is correct, Your Honor, and we don't believe that this court needs to construe anything related to Tennessee law because, again, this shouldn't be looked at from the standpoint of whether the vehicle is underinsured within the Tennessee nationwide policy. When you go back to Tennessee law and the statutory language that has been cited by the appellant in this case, or by the appellee in this case, that language in General Statute, or I guess it would be Tennessee Code 56-7-102, again, is talking about the policy against which the claim is made. Here, we're not making a claim against the nationwide policy, the Tennessee nationwide policy for UIM benefits. The claim is being made against the North Carolina Farm Bureau policy. So to analyze whether or not the vehicle is underinsured in the North Carolina Farm Bureau policy, we resort to the language of that policy in the North Carolina Financial Responsibility Act. Again, Benton arises in that unique scenario where the injured party is a passenger in the tortfeasor's vehicle. That is the only circumstance that I'm aware of under North Carolina law where the North Carolina court allows a party to stack the UIM coverage available under the tortfeasor's vehicle with that available under other policies, ensuring that injured party at the time of the accident.
Well, counsel, while you say that we should not adhere to any aspects of the Tennessee law, how should we reconcile the Tennessee definition of uninsured motorists as it relates to North Carolina law, but yet also consider the nationwide policy of the decedent that has the conformity clause in it that would tend to yield to the North Carolina law? Doesn't the Tennessee law have some interplay here?
Your Honor, again, I don't think it's necessary for the court to analyze Tennessee law because of the fact that policy benefits are being sought under the North Carolina policy. But to the court's point, if the court is to consider that language, when we look at the Tennessee statutory definition that's included in 56-7-102, the statute indicates that an underinsured or an uninsured motor vehicle does not include a vehicle insured under the liability coverage of the same policy of which the uninsured motor vehicle coverage is a part. So this is a simple statement that with respect to the nationwide Tennessee policy and under the nationwide Tennessee policy, Mrs. Lunsford vehicle or Mrs. Chapman's vehicle cannot be considered uninsured. The reason for that is it's covered by a liability policy issued by Nationwide in the state of Tennessee. If this court resorts to construing the Tennessee policy, I do agree with Your Honor that the conformity clause would allow this court to apply North Carolina law and to read the provisions of the Financial Responsibility Act in North Carolina into that policy. There is a substantial difference in Tennessee law versus North Carolina law as to how underinsured motorist benefits are calculated. Tennessee law does not permit stacking in the same way that the North Carolina courts and the North Carolina Financial Responsibility Act does. So again, because we're asking the court to construe her entitlement, Ms. Lunsford's entitlement, to benefits under the North Carolina policy, we believe the court is required to fall back to the North Carolina definition of underinsured motor vehicle.
In bringing in the Tennessee policy, which of course is a contract, are you representing here that the statutory law, including the FRA here in North Carolina, would trump any aspects of the Tennessee nationwide policy when it comes to construing contract law, since the contract would tend to typically supersede any other aspects that would operate here?
As applied to Ms. Lunsford as a North Carolina resident seeking policy benefits under a North Carolina policy, it is our position that the public policy of North Carolina and the avowed purpose of the Financial Responsibility Act requires this court to employ North Carolina law in making that threshold determination. The conformity clause in the nationwide Tennessee policy speaks to the concept of the types and limits of coverage available. We believe that UIM coverage is clearly a type of coverage that is provided under the North Carolina Farm Bureau policy. And again, that the court in analyzing that threshold issue is required pursuant to North Carolina law to stack the UIM coverage in the Tennessee nationwide policy with that in the North Carolina Farm Bureau policy. Now,
So is the effect of the decision that you're asking us to make in this case to be that anytime you have a North Carolina resident insured under a policy issued in North Carolina, that inter-policy stacking is required regardless of either the statutory law or the provisions of the policy of any other driver?
that is correct, Justice Urban, but only in the context of a passenger in the tortfeasor's vehicle seeking UIM coverage under their North Carolina policy. The circumstances would be
is the result that you're seeking us to reach in this case at all dependent upon the extent to which there are connections between the out-of-state policy and North Carolina?
We do not believe that the court needs to get into that issue in order to find in favor of Ms. Lunsford and to apply North Carolina law. But to the extent,
how do you get there given the necessity for us to give full faith and credit to the provisions of the law of other states?
we do not disagree at all with the concept that this court is required to give full faith and credit to the laws of the state of Tennessee in certain circumstances. And if we were asking this court to construe Ms. Lunsford's entitlement to UIM coverage under the Tennessee nationwide policy, we believe it would be entirely appropriate for this court to resort to the application of Tennessee law. But again, because Ms. Lunsford, as a North Carolina resident, is seeking a policy benefit that she has paid for in connection with her North Carolina policy, we believe that North Carolina law and only North Carolina law controls to determine whether the vehicle in question is a underinsured highway vehicle within the meaning of the North Carolina Farm Bureau policy. Going back to Benton, and again, in this unique circumstance where it's a passenger in the tortfeasor's vehicle, it is the only circumstance I'm aware of where the UIM coverage on the tortfeasor's vehicle is stacked with the UIM coverage for the injured party in making that threshold determination. So again, we don't think that Tennessee law is necessary, but to the extent that the court falls back on Tennessee law, the Martin opinion, which is cited by both parties in the briefing, indicates that a North Carolina resident's life is an interest insured under the nationwide policy. That would provide an alternative basis based on close connections with the state of North Carolina to read the Financial Responsibility Act into the nationwide policy if the court resorts to that application. So we believe that the court would be able to do that both based on the close connection to the fact that the nationwide policy was insuring a North Carolina resident in this circumstance, and based on the conformity clause requiring conformity of the Tennessee nationwide policy to account for the types and limits of coverage available in North Carolina. The additional slide I wanted to show to the court was simply the concept of the Benton court reaching that in keeping with the purpose of the Financial Responsibility Act, applicable UIM coverage may be stacked inter policy to calculate the applicable limits of underinsured motorist coverage for the vehicle involved in the accident for the purpose of determining if the tortfeasor's vehicle is an underinsured highway vehicle. In Benton, the coverages that were being considered are shown in the chart here. The $50,000 liability coverage when considered with all available UIM coverage. The court stated in its conclusion, using the general definition of underinsured highway vehicle, it follows that the nationwide UIM policy may be stacked with the progressive UIM policy to determine whether the Toyota is an underinsured motor vehicle. The amount of the stacked coverages on the UIM side, $150,000, is the applicable limit of underinsured motorist coverage for the vehicle involved in the accident. Because that amount exceeded the 50, the court made the determination that the Toyota in question was indeed an underinsured highway vehicle. When applying that same analysis to the Lunsford case, you have 50 in coverage under the Chapman nationwide policy. When considered with the stacked UIM limits of $100,000, the same conclusion rings true. Using the general definition of underinsured highway vehicle, it follows that the Chapman nationwide UIM limit of 50 may be stacked with the North Carolina Farm Bureau policy limit of 50 to determine whether the Chapman Silverado was an underinsured motor vehicle. When you consider the stacked coverage, the $100,000 with the liability coverage of 50, the Chapman Silverado is indeed an underinsured highway vehicle within the meaning of the Act, and Mrs. Lunsford should be entitled to underinsured motorist coverage under her policy. I do think it's important for the court to consider that this is the exact liability that North Carolina Farm Bureau bargained for in issuing this policy. If this was a North Carolina accident with the exact same coverages in play, they would be on the hook for the additional $50,000 in coverage.
Counsel, I'm reminded that you're well within your rebuttal time.
Yes, thank you. And I'm happy to let it rest here unless the court has any questions that it wants me to address at this time, and to turn it over to Mr. Lipscomb.
Thank you, counsel. We'll hear from the appellee.
May it please the court, I am Bill Lipscomb on behalf of the plaintiff appellee, North Carolina Farm Bureau Mutual Insurance Company. The North Carolina Financial Responsibility Act, the UIM statute, sets forth two requirements for a valid underinsured motorist claim. The first requirement is that the injured person has to qualify as an insured person of the UIM coverage. The second, and there's no question that Ms. Lunsford qualifies as an insured under both policies. The second requirement is that you have to be legally entitled to recover damages from the owner or operator of an underinsured motor vehicle. And as we've already talked about, the question here is whether Chapman's Silverado was an underinsured motor vehicle. Now, we don't dispute the concept of Benton versus Hanford, that in comparing the UIM limits to the liability limits, the injured person gets to combine or stack applicable underinsured motorist coverage. The North Carolina statute is very clear that you compare the liability coverage to the applicable limits of underinsured motorist coverage. So the real question here is whether Chapman's UIM coverage is applicable within the meaning of North Carolina's UIM statute. In order for Chapman's coverage to be applicable, Lunsford has to meet the requirements of Chapman's UIM coverage. And so in effect, Lunsford is making a claim against Chapman's UIM coverage because she has to meet the requirements of Chapman's UIM coverage. Now, clearly Nationwide would not have to pay out any money because Nationwide's liability coverage would be entitled, Nationwide's underinsured motorist coverage would be entitled to the credit for the liability coverage. So if Nationwide's coverage was applicable, the $50,000 UIM limit would be credited with the $50,000 liability limit that Nationwide has already paid to Ms. Lunsford. So in essence, Nationwide wouldn't have to actually pay out any money. But Lunsford, in effect, is making a claim under Chapman's UIM coverage because she has to show that it is applicable. She has to show that she meets both of the requirements of Chapman's UIM coverage. She can't meet the second requirement that is that she's legally entitled to recover from the owner or operator of an underinsured motor vehicle. Because Chapman's vehicle is not an underinsured vehicle with respect to Lunsford's claim under Chapman's UIM policy. And the
Mr.
reason,
Mr. Lipscomb, if I may, I need Justice Earls here. I want to make sure I'm clear about what you just said in terms of you're not contesting Benton. So if I understand your argument right, you agreed that if the nationwide policy had been issued in North Carolina, then Benton would require stacking to determine if the car was an underinsured car.
that's exactly right. Exactly right. Yes.
And so then what about North Carolina's statute suggests that there should be a distinction when interpreting a North Carolina policy regarding which other state the other policy might be issued in?
Well, because the North Carolina statute says that you compare the liability coverage to all applicable underinsured coverage in order to determine whether the applicable underinsured coverage is greater than the liability coverage so that the vehicle can be considered underinsured. And so our position in this case is that the UIM coverage of Chapman's policy is not applicable to Lunsford's claim. Therefore, the Benton holding simply does not apply because Chapman's coverage is not applicable. You can't stack what doesn't exist.
Mr. Lipscomb, it seemed if I was understanding the argument that Mr. Burton was making, and he's got a little bit of time to correct me if I was misunderstanding it, he is in essence, first of all, apparently arguing that it does not matter what either Tennessee law or the Tennessee policy says, because under the North Carolina Financial Responsibility Act, as interpreted in Benton, any and all policies that contain any uninsured coverage are deemed applicable for purposes of the relevant provision of the Financial Responsibility Act. Assuming, if you understood his argument differently, please tell me, but assuming I've got it correct, why do you disagree with what he says?
Well, I guess it basically goes back to what does the word applicable mean? The word applicable means capable of being applied. And so in order for Chapman's UIM coverage to be capable of being applied or, combined with Lunsford's UIM limits, all of the requirements for that policy have to be satisfied. And that policy was issued in Tennessee. It's governed by Tennessee law. The North Carolina Financial Responsibility Act is not written into Chapman's policy as a matter of law, as it was in the nationwide policy in Benton versus Hanford. In Benton versus Hanford, both of the policies at issue were issued in North Carolina. So the North Carolina Financial Responsibility Act was written as a matter of law into both of those policies. Not so here. And Tennessee law is very clear that an underinsured motor vehicle cannot be a vehicle that is owned by the named insured or insured for the liability coverage under the same policy. Chapman's pickup truck falls into both of those accepted out categories because Chapman owned the vehicle and the vehicle was insured under her liability coverage. Therefore, under Tennessee law and the Tennessee policy, Lunsford does not meet both of the requirements with respect to her claim under Chapman's policy. So,
Counsel Chapman's policy says in part, quote, "We will adjust this policy to comply with the financial responsibility of any state which requires higher liability limits than those provided by this policy," unquote. What relevance, if any, does that have in light of your argument?
okay, that is an excellent question. And I want to, before I answer that question, I just want to make the following statement that the only way that Lunsford can satisfy both of the coverage requirements of Chapman's UIM coverage is if the North Carolina Responsibility Act is written into Chapman's policy as a matter of law. That takes us to, and there's two theories. Lunsford argues two theories why North Carolina law should apply. One is she argues North Carolina case law. Mr. Burton has already mentioned the Martin case. There's also this court's opinion in Collins versus Aikman. The second reason is the cause, your question. The second theory as to why North Carolina, or the alternative argument as to why North Carolina's Financial Responsibility Act is written as a matter of law into Chapman's policy, is this financial responsibility clause that appears on page 24 of the record, and you have quoted it correctly. That entire sentence reads, "We will adjust this policy to comply with the kinds and limits of coverage required of non-residents by any compulsory motor vehicle insurance law or similar law." The North Carolina Financial Responsibility Act does not require a non-resident such as Ms. Chapman to have any kinds or limits of coverage for a collision in Alabama. It simply does not require a non-resident to have any kind of coverage for a collision in another state. And her focus on those two words, well, first of all, the main reason why our position is that this financial responsibility clause in Chapman's policy does not apply is because it is placed into the auto liability section of this policy, which this policy is divided into 4 coverage categories: physical damage, medical payments, auto liability, and uninsured, underinsured motorist coverage. It also has a general provisions section. Each of those sections is self-contained with its own page numbering system. The pages for this auto liability section are L1 through L5. This clause only applies to the liability coverage. The organization and placement of this clause is clear evidence that it only applies to the liability coverage. Courts from other jurisdictions, there's no North Carolina case that concludes this, but courts from other jurisdictions, I've cited them in my brief and the memorandum of additional authorities that I submitted last week, agree with that conclusion, that a conformity clause placed within the liability coverage of a policy applies only to liability coverage. And we're dealing here with underinsured motorist coverage. So that, I'm sorry, that was a long answer to your question, Justin Morgan. Also, I will mention that this financial, Lunsford focuses on the fact that the kinds and limits are plural. And her argument is that because kinds and limits of coverage are plural, it therefore is some indication that it applies not only to the liability coverage, but also to the underinsured motorist coverage. And as I pointed out in our brief, there are 2 types of liability coverage in Chapman's policy: bodily injury liability and property damage liability. Both of those coverage subsets are listed separately in the declarations page, and they each have their own policy limit. So the fact that this plural kinds and limits of coverage does not mean that it applies outside of the liability coverage. It only applies to liability coverages. The other theory that Lunsford advances to somehow make North Carolina's Financial Responsibility Act written into Chapman's Tennessee policy is the case law theory that I mentioned. This court, well, first of all, the Tennessee Code Section 56-7-102 states that every insurance policy that is issued to a Tennessee resident is governed by Tennessee law. And this court in Fortune versus Owens stated that the general rule is that an insurance policy that is issued in another state is governed by the policy of that state. Now, this court created an exception to that rule in the case of Collins and Aikman versus Hartford. The exception is that if North Carolina has close connections with the substance of the insurance policy, then that policy shall be deemed to have been made in North Carolina. That phrase, deemed to have been made in North Carolina, comes from North Carolina General Statute 58-3-1 that states that insurance policies, even though they're written in another state, are on property, lives, or interests in this state shall be deemed to be made therein. In Collins and Aikman, the subject matter of the policy was 102 trucks. That policy was issued in California. 97 of those 102 trucks were titled in North Carolina. And one of those 97 trucks was involved in a collision in North Carolina. This court held that North Carolina had close connection with the subject matter of that policy, enough so that it would justify concluding that that policy was deemed to have been made in North Carolina. The substance of Chapman's personal auto policy was her 2015 Chevrolet Silverado, which was owned by her in Tennessee. North Carolina has no connection with Chapman's policy. The fact that Lunsford was present in Chapman's vehicle in Alabama on May 22, 2017 is not enough to make the conclusion that Chapman's policy should be deemed to have been made in North Carolina.
Mr. Lipscomb, just to make sure I'm following you, is it your contention then that the necessary close connection that's referred to in this line of cases only exist in the event that the vehicle insured by the policy is registered or otherwise kept in North Carolina? Or is there some other way that you can get a close connection in your view?
With respect to motor vehicle policies, I would say that that is probably the only way that you can get that close connection. Yes, Your Honor, I think that's right.
Okay.
Because a motor vehicle policy, the primary purpose of it, the subject matter of a motor vehicle policy is the motor vehicle.
So in your view, the residence of someone who might be covered under a policy in another state by virtue of the fact of being the passenger in the car that's not a close connection?
I think that is correct.
Why not?
Well, let's take this particular case. She was a passenger in this vehicle on one particular day, May 22 of 2017. I think this court, it is our contention that is simply not enough of a close connection. I guess if it was, then on any given day, if there was a resident, if a passenger was from Alaska, Alaska law would have to apply to the policy on that day, or the next day a resident of Maryland was I just think that it would lead, I think that it would lead to absurd results. But in any event, in this, she was a passenger in this vehicle in Alabama on one day. I just don't think that's a close connection.
I want to, along the lines of the results of the argument, if I understand your position correctly, it really wouldn't matter whether there was any UIM coverage under the nationwide policy, because under your theory, that would still not make Chapman's car an underinsured car. Is that right?
If the underinsured coverage of Chapman's nationwide policy was applicable, then I think it would be an underinsured motor vehicle. If Lunsford could meet all of the requirements of the underinsured motorist coverage of Chapman's policy, both of the requirements, that is that she was an insured and that Chapman's vehicle was underinsured with respect to her claim against Chapman's policy, then I would agree that she could stack those coverages. But the Tennessee policy is so clear that Chapman's vehicle cannot be an underinsured vehicle because it was owned by Chapman and insured for liability coverage under Chapman's policy. Those accepted out categories are so clear that she simply cannot meet the requirements of Chapman's policy, therefore it's not applicable. But if the Financial Responsibility Act was written into Chapman's policy as a matter of law, so that those two accepted out categories were not valid, were not enforceable, then I would agree that the UIM limits of Chapman's policy would be applicable and could be stacked with Lunsford's UIM limits to meet the threshold issue. We wouldn't be here today if the North Carolina Financial Responsibility Act were written into Chapman's policy as a matter of law.
But you do agree that it's written into into Lunsford's policy.
Yes, absolutely.
And so in essence, our task is to interpret North Carolina law, the Financial Responsibility Act, and how it applies to a North Carolina policy. And I guess I'm struggling to see what part of our North Carolina law would say that in these circumstances, where we would otherwise allow stacking, it's not permitted.
Right.
Where is that in our statutes when we're interpreting the North Carolina policy?
Right. Understood. And my answer to the question is that our statute states that you compare the liability coverage to the applicable limits of underinsured motorist coverage in order to you compare applicable UIM coverage to the tortfeasor's liability coverage. And in this particular case, Chapman's UIM coverage is not applicable within the meaning of the North Carolina statute because Lunsford cannot meet both of the requirements. The second requirement is the one here, that Chapman's vehicle is simply not an underinsured motor vehicle with respect to Lunsford's claim against Chapman's policy. She has to meet. Both policies have to be looked at separately. And when you look at Chapman's policy, it simply doesn't apply. The coverage is not available because her vehicle cannot be an underinsured motor vehicle for a claim against that policy.
And are you accepting the Court of Appeals majority's view that the reason why the decedent's or Chapman's vehicle was not underinsured under Tennessee law is because the coverages of the plaintiff here, of the defendant here and the decedent were tantamount to being exactly the same?
Well, I read the Court of Appeals opinion a little differently.
But do you agree that that's what they say, first of all, even though you read it differently?
I certainly agree that the result that they reached is the correct result. But it's my understanding that the basis of the Court of it. Well, let me back up. I do agree that the Court of Appeals made the conclusion that Chapman's underinsured coverage was not applicable. And therefore, the only underinsured coverage that would possibly be available was Lunsford's UIM coverage. And the $50,000 of Lunsford's UIM coverage equals the $50,000 of Chapman's liability coverage. 50 equals 50. Therefore, Chapman's vehicle was not underinsured. Yeah, that's what the court of, and I agree that that's what they say. They say, they also, the Court of Appeals also said that Chapman's UIM coverage was not applicable. Therefore, the only UIM coverage was Lunsford's 50, and 50 equals 50. Therefore, it wasn't an underinsured vehicle. That's correct. I'm sorry, I misunderstood your question initially, but now I've got it.
But
Okay,
I go ahead, Justice Morgan.
Thank you. I was just going to wrap that up. So you do agree with that premise, and you're relying on that premise concerning the underinsured coverage aspect, that the reason why the vehicle of the decedent is not considered underinsured is because the coverages were the same between the two policies.
That's right. Well, looking at Lunsford's claim under her own policy, yes, because Chapman's UIM coverage is not applicable, the only UIM coverage that is available to compare with Chapman's liability coverage is Lunsford's UIM coverage, which is 50,000 per person. So 50 equals 50, and there's no, yeah, her vehicle is not underinsured.
Mr. Lipscomb, I had understood you to say that in your brief that you did not agree with the Court of Appeals' emphasis upon the distinction between Class 1 and Class 2 insureds as one of the reasons why the Tennessee policy wasn't applicable. You are saying that, aren't you?
Yes, yes, yes. Right. And the Court of Appeals, there really is, with respect to the Class 1 insured and Class 2 insured get the same benefits. Class 1 and Class 2 distinction simply involves the different types of scenarios that would allow a person to qualify as an insured. But once you're an insured, you're an insured, and you're entitled to all the benefits under the policy. So I did not understand the Court of Appeals reasoning there. There's no dispute that Lunsford meets the first requirement under Chapman's policy. As an occupant of Chapman's vehicle, she qualifies as an insured. And the only reason that Chapman's UIM coverage is not applicable for Lunsford's claim under Chapman's policy is, as I've already said several times, Chapman's vehicle cannot be an underinsured vehicle for a UIM claim under her policy. In conclusion, if there are no further questions, Farm Bureau respectfully requests that this court affirm the result of the Court of Appeals and modify its opinion to state that Lunsford is not entitled to UIM coverage from her policy because Chapman's vehicle was not an underinsured highway vehicle, because there is no other UIM coverage to compare, to stack with Lunsford's UIM coverage to get over that threshold number.
Thank you, counsel.
Thank you
Any
very
rebuttal?
much.
Yes, Justice Newby. When construing a North Carolina insurance policy, North Carolina courts are restricted, or construing an auto policy, North Carolina courts are restricted to two things: the language of the policy and the mandates of the Financial Responsibility Act. When we look at page 69 of the record in this appeal, which is the North Carolina Farm Bureau policy, the policy language that we're asking this court to consider is North Carolina Farm Bureau's commitment that we will also pay compensatory damages which an insured is legally entitled to recover from the owner or operator of an underinsured motor vehicle because of bodily injury sustained by an insured and caused by an accident. The only way that this court can reach the conclusion that Ms. Lunsford is not entitled to coverage under her North Carolina Farm Bureau policy is to read the Tennessee statutory definition of underinsured motor vehicle into a North Carolina policy and to hold that definition against a North Carolina resident. We would submit that that would be at odds with any of the North Carolina case law construing the North Carolina Financial Responsibility Act. I think it's also important to note that if we take North Carolina Farm Bureau's argument to its logical conclusion, that is that Ms. Lunsford or Ms. Chapman's vehicle can never be an underinsured motor vehicle because the policy language excludes it from being so. If the facts were different and the injured party in this case had a $1 million UIM limit under their own auto policy, the same argument that could be made because all UIM coverages require a legal entitlement to recover damages from the owner or operator of an underinsured motor vehicle. Even if there was a $1 million UIM limit, the nationwide policy language, if you accept North Carolina Farm Bureau's argument, would prevent the Chapman Silverado from ever being characterized as an underinsured highway vehicle. Again, we go back to the idea that the question of whether it's underinsured within the meaning of Mrs. Chapman's own Tennessee nationwide policy is not in any way dispositive on whether it qualifies as an underinsured highway vehicle under North Carolina law pursuant to the North Carolina insurance contract. When we talk about this concept of applicability, applicable does not mean capable of payment. The Benton court has indicated in the Benton opinion, which North Carolina Farm Bureau does not challenge, says that applicable is required in addressing the threshold issue of what UIM coverage is available. The Court of Appeals, in their opinion, correctly stated that a policy is applicable if the person is insured under the policy, but then employed the incorrect analysis pursuant to Sproles and reached the flawed conclusion that Ms. Lunsford was not an insured under the policy, the nationwide policy, even though the plain language of the nationwide policy says that she is insured. The policy is applicable within the meaning of North Carolina law. It's applicable because Ms. Lunsford was indeed an insured under the nationwide policy at the time of this accident. I go back to the idea that this is a bargain for contractual right that Mrs. Lunsford is entitled to, and it is the exact liability that North Carolina Farm Bureau bargained for in issuing this policy. As Mr. Lipscomb's papers admit, if we were dealing with a North Carolina policy on the nationwide side, Benton would apply. There would be $100,000 of UIM limits, which when compared to the nationwide liability limit clearly indicates that the Chapman vehicle was underinsured at the time of this accident. Because it was underinsured, we believe the Court of Appeals erred in reaching its conclusion, and we would ask this court to reverse so that Mrs. Lunsford can collect the policy benefit to which she is entitled.
Thank you, counsel. Thank you to everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Thank you, counsel.
Thank you.